Hi, my name is Kevin O'Shea. I'm a partner at the Intellectual Property Group of Ice Miller in Chicago. You may recall me from other videos such as Intellectual Property Basics. Today we're going to be talking about something much narrower, but something that has been in the press a lot lately, and specifically inter-parties reviews of patents. Inter-parties reviews provides a faster forum for patent litigation and therefore is often considered both a sword and a shield. That is, it is an offensive and a defensive weapon available to patent owners and competitors. So let's jump in. What is an inter-parties review? An inter-parties review is essentially litigation light. It is much more focused, it is faster, and it is less expensive than typical patent litigation, which, as we all know, can be very both lengthy and expensive. An inter-parties review, or an IPR as we refer to it, is conducted before the Patent Trial and Appeal Board of the U.S. Patent and Trademark Office. The Patent Trial and Appeal Board is made up of administrative law judges rather than U.S. District Court judges. There's no jury. Instead, there's a hearing at the end. So it's much more focused proceeding than a U.S. District Court proceeding. An IPR is focused only on specific invalidity issues relating to patents. So no infringement issues are addressed and no enforceability issues are addressed, which allows it to be, as I said earlier, more focused and much quicker. It is litigation though. And so, for example, both parties are going to be involved. Both parties have an opportunity to take discovery, much like in a district court litigation. However, where in district court litigation, discovery can be broad and all but a fishing expedition, in an IPR, the discovery is very limited and very focused only on the issues at hand. The administrative law judges do not let the parties vary or go fishing for anything beyond what is really at hand. So it's a very focused discovery period. You can seek additional discovery, but it's frankly very rarely granted. And even then, it's still going to be very narrow, and administrative law judges are going to rein in the parties and keep the IPR moving forward. Again, there's no jury trial. There's no jury. This is an administrative proceeding. So at the end of the IPR, there's no jury trial, but instead it concludes with a hearing before a panel of 3 administrative law judges. The hearing lasts several hours. It is based upon pre-hearing briefing rather than, again, in front of a jury. A particularly nice thing about an IPR is that it must be completed within 1 year after the Patent Trial and Appeal Board institutes the IPR. So what happens is a party asks the PTAB to institute an IPR and explains in a very lengthy submission exactly why the party thinks that the patent at issue is invalid. The Patent Trial and Appeal Board has 3 months to decide whether to institute the IPR, and if they do, once they institute the IPR, they have exactly 1 year to issue a final decision. So everything's got to happen within that 1 year. Again, that makes it a much faster resolution of a patent issue than in district court, which can range anywhere from, even at the very fastest range, from 1.5 years to easily 3 years or possibly even more. Once the IPR is completed, once the Patent Trial and Appeal Board issues its final ruling saying yes or no as to the invalidity issue, either party who isn't happy with the ruling can appeal to the U.S. Court of Appeals for the Federal Circuit. That's the appellate court in Washington that oversees all patent appeals in the country, so they are obviously well versed in what they do. Interestingly, unlike other proceedings that go forward in the U.S. Patent and Trademark Office, an IPR can be settled. So along the way, the parties can come to an agreement and wrap it up and settle it. The PTAB has to agree to end the IPR. But for the most part, unless you're really at the end of the IPR proceeding, the PTAB is going to let you settle. So, unlike other proceedings before the U.S. Patent and Trademark Office, IPRs can be settled, which is a significant advantage of an IPR. Now, who can file an inter-parties review? Anyone. Anyone except the owner of the patent. So any third party, any citizen, anyone, a competitor, for example. There's no need to show any dispute between competitors. So if you have a competitor and they are, for example, going to launch a new product and you have a patent that may in fact cover that new product and therefore you would block them from coming out with their new product, or conversely, you're coming out with a new product and you have a competitor whose patent may block your new product, you can consider filing an IPR and invalidating that patent, or the competitor can consider filing an IPR against your patent. Also in response to a cease and desist letter. Maybe you get a cease and desist letter from a competitor or from a random patent owner, what has commonly been referred to as patent trolls, parties that just own patents and assert them against companies. So you get a cease and desist letter that says, stop what you're doing. Maybe something about your internet website, maybe it's a product, but stop what you're doing, you're infringing my patent. A response you can consider is to file an inter-parties review seeking to invalidate that patent. Much quicker than going through district court litigation, much less expensive than going through district court litigation. Also, an IPR is a good way to clear the way for a new product. You're coming out with a new product, you're concerned about the patent landscape, maybe there's a patent out there a competitor owns, or just some random patent owner, you can file an IPR against it, seek to invalidate it. Again, you could settle that matter just because you've requested the inter-parties review, and just because the PTAB has begun it and it is ongoing doesn't mean you're locked in. You can settle it. So it's a consideration in a situation like that. Another group that can file an IPR, again, it's anyone, but strategically another group that typically considers filing an IPR are accused infringers and litigation defendants. So you've been sued. You've been sued for patent infringement, and you're considering your options. You're looking at potentially a very long proceeding, a very expensive proceeding in a forum, a district court, where you're not home. So it could be far away, it's going to be expensive. You can consider, as the accused infringer, filing an inter-parties review. The advantage is, one, you're going to get the invalidity question answered at the U.S. Patent and Trademark Office. Two, the district court may well postpone or stay the litigation pending the outcome of the IPR. Because the IPR happens quickly, the patent office moves fast through an IPR, district judges oftentimes will stay the litigation and wait to see what the PTO does. Now, your chances of staying litigation are much higher the earlier you file your IPR and ask the district court to stay the litigation. If you're well into it, you're deep into your litigation, you're getting close to trial, very few judges will stay the case at that point. But if you're at the very early stages, the complaint's been filed, maybe you're just getting into discovery, you have a fairly good likelihood of getting the court to stay the litigation. So then you're not moving on two separate tracks. The litigation stays sort of on the shelf, the inter-parties review goes forward, you get the validity decision determined, and again, you can always settle it. There is a deadline. If you are sued and a complaint is served upon you, you have 1 year to file an inter-parties review. You can't file it more than a year after the complaint has been served. That's in the rules. Another group that has begun to file inter-parties reviews are investors who are believed to be short-selling stock. This has become, in 2015, a significant activity in the pharmaceutical industry where activist investors are filing inter-parties reviews seeking to invalidate key patents owned by pharmaceutical companies. The purpose is to short sell the stock on the one hand, and two, to force a settlement, a cash settlement on the other hand. Under the law, as it reads right now, that is presently a perfectly acceptable thing to do. Just something to be aware of. If you're seeing activity on your stock or you're hearing rumblings, be aware that you may be facing an inter-parties review of one or more of your key patents that you'll have to deal with that would be filed by an investor or by a short seller. We've gone over inter-parties reviews very quickly. This has been a very brief review of a very, very complex area. There's a lot more to it. There are other proceedings that are available at the Patent and Trademark Office that may be better or more appropriate for your particular situation. The point is, I want to make sure that you have an opportunity to think about what may be out there as an option for you, both a sword and a shield, an offensive and defensive weapon that's available to you at the United States Patent and Trademark Office. Again, it's a faster, more focused proceeding than U.S. District Court litigation. There's a lot more to it, a lot more to the strategy, a lot more to the procedure, so please feel free to give me a call. My contact information is on the screen. Feel free to give me a call or email me at kevin.o'shea@icemiller.com. Thank you very much.